Ladies and gentlemen, welcome to the National Constitution Center and to our Town Hall Tuesday about the First Amendment rights of corporations and individuals. I'm Jeff Rosen. I'm the president of this wonderful institution. During the many moving moments I've had since I started here in June, I think there are few more meaningful than the sight of all of you who've turned out in this great snowstorm, which has closed schools around the country and has deterred transportation, but has not deterred this hardy band of lovers of constitutional debate who are so committed to understanding one of the most important and complexing constitutional questions facing the country that at great inconvenience to yourselves, you've showed up for this discussion. So thank you so much. I appoint all of you contributing scholars in the face of arduous weather conditions and really appreciate your showing up. I also need to express the deepest appreciation to our two panelists who have come from Washington, D.C. and caught their train this morning. And you all know that unlike Philly, Washington, D.C. closes at a single snowflake. It's really not great in the face of extreme weather conditions. It's like the government shutdown. Yes.
I don't understand any of this. I grew up in Canada. There's no such thing as a snow day.
Exactly. But like you, they are passionate and ardent, I should say, in their commitment to bipartisan constitutional discussion. So thank you on behalf of the National Constitution Center. All right, so we have a hard question to talk about today. The question broadly is, do corporations have the same religious freedom rights under the First Amendment as individuals do? And secondarily, does the mandate in the Affordable Care Act that requires for-profit corporations to provide contraceptive coverage, although it makes an exception for some religious institutions, does that violate both the First Amendment and also the Religious Freedom Restoration Act, which is a law Congress passed that provides many of the same protections as the First Amendment? So it sounds a bit technical, but it's extremely important. It ties into the broader question that is transfixing the country of whether corporations have the same First Amendment rights in general as individuals do. The Supreme Court put that question front and center in the Citizens United case when 5 justices said that corporations and natural persons do have the same free speech rights when it comes to campaign finance reform. And the question the court will hear later this year in the 2 cases that it agreed to hear on Tuesday, November 26th, is whether the rights of corporations are the same for the purposes of the free exercise of religion part of the First Amendment, as well as the free speech part. So that's the broad question. We are just going to learn together because, like all hard constitutional questions, there are no easy answers to this one, and our 2 panelists are going to help us illuminate this hard question. Let me begin with David. David, and first of all, let me introduce our very distinguished panelists who are good friends of the National Constitution Center. I should say that they've been participating in a series of constitutional podcasts that we've been sponsoring every Friday, and I hope that you will go online and either subscribe through iTunes or find them on our website. Week after week, both David and Ilya and other scholars from around the country have been having debates of about a half-hour long of the kind that we're going to have now. They're moderated conversations. They've been widely downloaded, and I've just found them thrilling because, unlike Crossfire, people are actually learning from each other and trying to come up with a little bit of wisdom. So please continue the conversation on our podcast. Let me introduce them briefly. You have their bios. David Gans is the Director of Human Rights, Civil Rights, and the Citizenship Program at the Constitutional Accountability Center. He's served as Program Director of Cardozo Law School's Center for Constitutional Democracy and has worked for the Brennan Center for Justice. I should say the Constitutional Accountability Center is a wonderful organization in Washington that files briefs before the Supreme Court arguing that constitutional text and history, if properly understood, may lead to results that sometimes favor liberals and sometimes favor conservatives. So they're basically liberal originalists who are trying to make arguments about original understanding to persuade the court to sometimes favor progressive causes. Ilya Shapiro is Senior Fellow in Constitutional Studies at the CATO Institute and Editor-in-Chief of the CATO Supreme Court Review. He has been an advisor to the multinational force in Iraq. He is a regular commentator on all the major media outlets. And I've just found Ilya, on behalf of the CATO Institute, really one of the most thoughtful and prominent commentators from a more libertarian point of view. And you know the Cato Institute is a libertarian think tank. It defends individual liberty, whether that is in the economic or social sphere. So it sometimes discomfits people on the left and the right, but it is deeply principled in its devotion to individual liberty. So here are two great panelists. David, you have filed a brief in the Hobby Lobby case, which the Supreme Court agreed to take up, arguing that the framers of the First Amendment would not have intended corporations to have the same religious liberty rights as natural persons. Tell us more about that argument.
Well, so when we look back at the framers and the original understanding of the free exercise right, the framers rooted in fundamentally human attributes. They talked a lot about reason, they talked about conviction, they talked about conscience. So if you look either the debates over the free exercise clause, which admittedly were sparse, if you look at those, if you look at the plethora of state constitutions that were drafted that influenced the framing era's understanding of the free exercise right, or if you look at Madison's sort of iconic statements about religious liberty, they all talk about reason, they talk about conscience, they talk about conviction. At its heart, the free exercise right is a right that is about human dignity, and those human attributes don't apply to business corporations. So if we look at the framers' understanding of the right, this is fundamentally an inalienable human right of the kind that was described in the Declaration of Independence, and is not one that extends in the same way to business corporations. I'll sort of note two other points to kick things off. One, in over 2 centuries, the Supreme Court has never suggested that the free exercise right is one that protects business corporations. And I think until these disputes, there's not even been a suggestion that this is a right that business corporations possess. And I think that reflects that there's a fundamental difference between we the people and business corporations when it comes to matters of conscience and human dignity, and when the Supreme Court has dealt with other rights that are fundamentally about human dignity and conscience. They've said business corporations have a number of rights under the Constitution, but there's some, particularly ones that go to human dignity, that they don't possess. And lastly, I think one of the very troubling aspects of these cases is the claim made by Hobby Lobby is that its owners can impose their own religious views on their employees, who of course are not required to share those religious views, and who may want and need access to the full range of contraceptives. So, in some ways it raises this broader question of sort of whose religious liberty and how do you deal with the competing claims of owners and the employees. And I think if you look back at what the Supreme Court has said, they've always expressed the idea that there's something troublesome about allowing a business owner to impose his or her religious views on employees, especially when it means denying important federal rights that are protected by, in this case, the ACA.
Wonderful, David. Thanks for kicking us off so well. So Ilya, David made 3 broad points. One was about the original understanding of the framers, the second about Supreme Court precedent, and the third about the practical consequence of recognizing this right. Let's hone in on the original understanding argument first, and you can respond to the others in a moment. David basically says the framers thought of religious freedom as a natural right that comes from God and not government. Madison believed that we couldn't alienate this natural right because our religious beliefs were the product of external impressions operating on our minds. Religious worship was a duty, and that's why there was a corresponding right that couldn't be alienated. David says that can't belong to corporations. It has to belong to natural persons. What's the response to that?
Well, that's true to a point, in the sense that whatever rights corporations have, whether in the religious area, in political speech, or anything else, isn't because they are legal persons. It's because they're derivative of the rights of the natural persons of which they're composed. We don't create new rights or new beings that have new rights when we create or recognize corporations or any other type of associations, LLCs, partnerships, unions, private clubs, an institution like the National Constitution Center. All of these different organizations or agglomerations of people have rights to a certain extent. So, I don't think David goes as far as to say people getting together, or even in the corporate form, corporations have no rights whatsoever because, for example, the police couldn't raid IBM and take all of their computers and files without a warrant. They have Fourth Amendment rights. The mayor of New York couldn't say he wants to move his office to Rockefeller Center and therefore take over NBC studios without paying just compensation. They still have Fifth Amendment rights. So really what this discussion is to what extent are the rights, in this case the religious liberties of individuals, how do they work in the corporate form? And it's kind of tricky dealing with it from an original perspective because corporations as we know them, modern corporations or other types of business associations, didn't exist in the founding era. Whenever you come across the idea of a corporation from Thomas Jefferson, from others, they're talking about government-granted monopolies, like the British East India Company, for example, or other sort of corporate charters that were granted by the government, kind of a quasi-governmental agency, I guess you could call it. Maybe the closest thing that we have now would be like a Fannie or a Freddie or the Postal Service, something like that, maybe an Amtrak, something like that. But it's not your kind of typical for-profit corporation. So the real inquiry here is, are individual rights, in this case again, religious liberties, being violated unduly under the Religious Freedom Restoration Act, under the First Amendment, when the government makes certain demands of corporations that are closely tied or tied to a sufficient degree to those individuals.
Great. So David, this is a powerful response Ilya makes. He says the framers couldn't have thought about corporations in the modern sense because those didn't exist. And we have to translate the framers' notion of individual liberty to a world where individuals aggregate together. Is it your position that corporations have no rights, or do you just believe that if I'm a for-profit corporation and I'm religiously motivated, I should sue in my personal capacity? As the DC Circuit held, they didn't say you can't come into court. They just said the owner of Hobby Lobby, who's a Christian bookstore owner himself, should sue and say that his rights, along with the people he chose to associate with, were being violated. That would get them into court. Is that the only difference between your two positions?
Well, so the point about the text and history is not a point about what was the status of corporations at the founding. And everybody recognizes that corporations have changed since. The point is, what is the nature of the right that we're talking about? There are certain rights in the Constitution that have extended to corporations. So Ilya mentioned the Fourth Amendment example. The issue that Hobby Lobby raises, and it's profound because, as I said, for over 2 centuries, the Supreme Court has never said that business corporations have these rights that are closely tied to human dignity and conscience. And in fact, they've never, no case, not even since United, have said rights of human dignity belong equally to individuals and business corporations. So the key question, I think, is the nature of the right. And I think if you look at that founding understanding, which, again, is still very much our understanding that free exercise is a matter of conscience, those rights do not extend to business corporations for the reason that corporations don't pray, they don't express pious devotion to God, they don't have a religious conscience. A second point I think I would make is, yes, corporations are different now, but you can look at the whole sweep of American history and the evolution of the business corporation model. And throughout that whole history, there has never been a claim that business corporations are persons exercising religion. And that's really the question before the court. And I think it would really be a momentous break from not only the sort of foundational text and history, but the whole sweep of American history to say that business corporations have the same rights as we the people to engage in acts of religious free exercise. So corporations have some rights, but the Supreme Court has recognized they don't have all rights, and when you're dealing with purely personal rights that really inhere in human dignity and conscience, those are rights that the law guarantees to individuals and not to business corporations.
Great. So the strong response is first the precedent point, which he makes again. he says the Supreme Court has never before recognized a secular for-profit corporation as having rights under the Free Exercise Clause. That's the claim of the Obama administration. Is that correct as a matter of precedent? My understanding is that Jewish merchants in the 19th century did challenge Sunday closing laws, but I think they lost, as it happens. So tell us more about that history.
That was a curious kind of case. They challenged, these were Jewish merchants. It's not a synagogue, it's a going concern. I'm not sure whether it was a Schedule S corporation or whatever it was, but and they challenged the Sunday closing laws. Of course, for Jews, Saturday is the Sabbath. But they said that because by our religious law we have to close on Saturday, now the government is telling us we have to close on Sunday, so we can only operate 5 days a week, which puts us at a disadvantage against our competitors who can operate 6 days a week. And because of the curious way that that came up, that challenge came up, they did lose. There were other cases that seemed to, suggest that if the government said that you have to open on the Sabbath or do other things. I mean, I think it's not really controversial that in certain contexts, it's not the corporate form that matters again, but whether the people who are who possess the rights when they're acting through the corporate form in terms of social responsibility or whatever type of guiding mission they want their business to have. I don't think the point is that when they're operating in a commercial manner, that at that point they lose rights. And I've forgotten, Jeff, as I always do when I come here, I come bearing gifts.
Okay.
This is a law review article. I have one for each of you.
I couldn't be more excited.
Called So What If Corporations Aren't People? Okay? Nobody is disputing that corporations, qua corporations, don't pray or believe in God or all these sorts of things, or get down on their knees. They don't have knees, right? It's not a point about anthropomorphizing the corporations, but clearly, in practical terms, if you mandate a corporation to do something that its owners find religiously offensive, it doesn't matter if it's a corporation acting versus its owners in their individual capacity. They will feel that burden. Let me read to you. This is a very short quote, footnote 14 from the Third Circuit case, Conestoga Lumber. That's also the companion case to Hobby Lobby that's going to come before the court. The all-important footnote 14 from the dissent. The majority thinks it important that corporations lack the anthropomorphic qualities of individual religious devotion. Quote, they do not pray, worship, observe sacraments, or take other religiously motivated actions separate and apart from the intention and direction of their individual actors. Of course, corporations do not picket or march on Capitol Hill or canvass door to door for moral causes either. But the majority would not claim that corporations do not have First Amendment rights to free speech or to petition the government. Corporations have those rights not because they have arms and legs, but because the people who form and operate them do. And we're concerned in this case with people, even when they operate through the particular form of association called a corporation. It's perhaps no accident that the only support my colleagues put forward to show that a corporation's lack of body parts deprives it of religious liberty is a district court case that's been reversed, a dissent in a Court of Appeals case, and a dissent in a Supreme Court case. An argument that's lost 3 times is not necessarily wrong for that record, but maybe the record says something about the argument. So I think that, again, it's not a matter of when you're engaging in commercial activity that's the dividing point. That's certainly the position that the administration takes. I don't think David has taken that position in the past, or at least CAC has, because, of course, you have a host of other types of religious businesses, a Christian bookstore, say, that is involved in commercial activity. The Catholic Church is involved in commercial activity to a certain extent. But I think there must be something peculiar to this corporate form that does it, and I want to hear what that exactly is.
Great. Help us understand this corporate form, David, because I don't quite get it yet, and I think it's the key to the case. Ilya cites from Judge Kent Jordan's dissent in the Third Circuit. The Third Circuit includes Pennsylvania, and Judge Jordan is a neighbor, and it's a judge right nearby. And he cited the Citizens United case for the proposition that corporations do have some constitutional liberties. This corporate form question, is the only disagreement between you saying that the corporation can't sue in its collective capacity, but a bunch of individuals who own a corporation may be able to sue in their individual capacity and say that their personal free exercise rights are being violated? And if that's the case, is there much difference between your two positions, or am I missing a wrinkle that makes the question of corporate form more complicated? Help us all understand.
So let me start by going back to the Jewish merchant cases that Ilya started with, and emphasize so one, there have been over the course of American history a number of cases where individual business owners brought free exercise claims to the court. A couple of them have made it all the way to the Supreme Court. I mean, one thing you'll note is the record is of complete failure. So there's the Jewish merchant case, which ultimately goes to the Supreme Court in the early 60s. It's called Braunfield versus Brown. There's a very important case called U.S. versus Lee, which is about an Amish owner who said, I need an exemption from the Social Security system because that conflicts with Amish owners. And in these cases, I think like Hobby Lobby, the owner said, we just want to run our business according to the dictates of our faith. And in all of these cases, the court rejected that claim. And I think Lee is particularly important because the court said, once you enter the business world, you can't, an exemption from Social Security would impose your religious beliefs on your employees who don't have to be Amish, and very well need the protections that Social Security provides. Two, there's a distinction between the rights of business owners and the rights of business corporations, at least in some contexts. And so, one area that I think is quite important in these cases is the Fifth Amendment self-incrimination clause, which is a part of the Constitution that for over a century the Supreme Court has said does not apply to business corporations. And the reason it has is very much to do with this dispute. It's about conscience. It's about human dignity. And those protections just don't apply to business corporations. So an individual business owner who's not incorporated can assert an objection based on the privilege against self-incrimination. But a business corporation simply can't. And a business owner can't say, well, I in my individual capacity have a privilege against self-incrimination. And the Supreme Court has said, no, when you're acting on behalf of the business, you're not acting in an individual capacity. You're acting for the corporation. And whatever rights you have are the rights of the corporation. And I think that's why the key question is the nature of the right. And if you look at this right, this is a right that's very much about dignity and human dignity and individual conscience. And it's not a right that business corporations have for that reason. And I think there is a pretty fundamental distinction between this and Citizens United. I mean, one, the issue in Citizens United was not, do corporations have rights under the free speech clause? The Supreme Court had said that for many, many decades. The issue in Citizens United was, do they have the same rights? So the issue, and they said yes, and the main reason was because any speech, especially on matters of candidates' fitness for election, for serving as president, and in that case it was about Hillary Rodham Clinton, who Citizens United did not think would make a good president. That speech, whoever says it, benefits human listeners and enriches democracy. And so the idea was, we don't really have to focus on whether the corporation has a right, because individual listeners have rights to hear the speech, and therefore you can't have the limitation that was struck down in Citizens United. Here, I think the focus in the free exercise case is very much on sort of the relationship between the individual and the God and matters of conscience. And I think that forces you to go to these questions of, does a business corporation, can that be treated as a person exercising religion? And I think the Fifth Amendment example is a good example that even rights that protect persons, some of those don't extend to corporations. So the derivative point that Ilya mentioned holds true, but it doesn't mean that business corporations have all the same rights. And I think the court has recognized that there's a problem with a business owner wanting to kind of go back and forth between individual and corporate status so that when it comes to limited liability and obtaining all the special privileges, they like corporate status. But when it comes to saying, well, I have a deeply held conscience, they want to be an individual. And you can go back as early as some of the foundational precedent on the rights of corporations. I'm thinking of the cases from the early 19th century about the rights of business corporation under Article 4's Privileges and Immunities Clause. And the court said, if an individual wants to be considered, if a corporation wants to be considered as an individual carrying on a business, then he can also take the liabilities of an individual. And the answer was, that's one of the reasons why we reject this notion that that business corporations have all the same rights as individuals. And I think if we kind of dig deep, not on sort of corporate personhood across all constitutional rights, but on the particular right at issue here, the free exercise clause right, you get to the conclusion that these are rights that are about conscience, human dignity, and don't extend to corporations the way they protect living, breathing humans.
Great, so that's quite an extensive answer. I'm eager for your response, Ilya. I think the answer may be in this excellent law review article, which I'm looking forward to reading, and which I commend to all of you, the John Marshall Law Review, The Impact of Citizens United, Corporate Speech.
No, that was the symposium. The name of the article is So What If Corporations Aren't People?
Forgive me. So what if corporations aren't people? And you'll tell us that. But Ilya's saying, he's not saying they have no rights, just that they don't have the same rights. And he gave a couple of examples where the Supreme Court has said, if the right involves human dignity, like the Fifth Amendment, where the framers are centrally concerned with not putting an individual under oath and forcing them to choose between self-incrimination and eternal damnation and contempt. Self-incrimination, perjury, and contempt. That's the cruel trilemma. That's why you don't put an individual under oath, but you can't have a corporation blaspheme itself under eternal damnation. Therefore, corporations don't have the same Fifth Amendment rights as individuals. Give us your sense of whether, what's your response to the claim corporations have some Bill of Rights, but not all the same ones?
Sure, I agree that corporations don't have souls, but that's not why.
You've never met Google.
Right. Well, Google says don't be evil, right?
Yes.
So that's but in all seriousness, isn't that kind of their corporate mantra? They try to conduct their business in a way that doesn't promote evil. That might be kind of a far-fetched example. Google's now a public company, and there's different things about how much the founders control and all these other types of questions. But in Hobby Lobby's case, I mean, it's quite clear this isn't the kind of this isolated circumstance where they decide, well, we object to these types of drugs, and therefore it would violate our rights. They don't on their trucks. They don't allow shipment of beer. They don't sell shot glasses in their stores. They play what they consider to be positive, life-affirming music. I mean, there's a whole way that they conduct their business, and lots of business owners, Starbucks has their own sort of mantra about fair trade coffee and what have you. I mean, what if the coffee producers lobbied Congress and you had a regulation that you have to sell this type of coffee, and it's not necessarily fair trade, and they can't conduct their business the way they are. Is that a religious belief? I mean, I don't know, but I mean, if you take these sorts of mandates to their ultimate conclusion, you have a lot of violation about how corporations want to conduct themselves. It's not, again, the corporation is an inanimate legal fiction. It's the people who are owning the corporation. In this case, if Hobby Lobby or Conestoga Lumber doesn't comply with this mandate, they're going to be fined. That fine ultimately comes out of the pocketbooks of the individual owners who control these companies. So the analysis, might be different. I'm not trying to draw a distinction between closely held companies versus public companies. The analysis might be more different about, how really much are you being affected, you as an individual in the larger public company? Are you a shareholder? All these different things. But we have to observe the legal fictions in that, for example, one reason we have the corporation is that if it's wronged, it can just sue as a corporation rather than having to have all of these co-plaintiffs from the million shareholders or what have you. There's a lot of reasons that facilitates commerce that we have, or for lawyers set it up to do special types of tax treatment or what have you. But there's definite connections to the individuals. And in this case, just like having a Fifth Amendment protection against self-incrimination for a corporation, doesn't do anything for the individuals. Maintaining this protection in the context of religious exercise does help the individuals promote and preserve their own liberties. As I agree with the cases that David mentioned, and John Roberts wrote for a unanimous court a couple of terms ago in this AT&T case, which concluded with, it was about denying the idea that corporations have privacy. And he said the last line was, "I hope AT&T doesn't take this personally." And again, that's true. What we're debating here is the scope of these rights. And here, whether you consider it, I don't have much of a dog in the fight about whether the ultimate jurisprudence should see this as kind of a pass-through right from the corporation to the individual, or the individual suing in his own capacity as, even though the mandate applies to the corporation, not to him directly. However lawyers want to articulate that is really fine with me. But the ultimate point is that we have these constitutional protections to protect individual liberty, and you don't lose those when you form a corporation. So I think what I'm hearing is that you don't necessarily lose those when you engage in commercial activity, because individuals can engage in commercial activity, as themselves, as partnerships, as other forms. But I don't know what there is that's special about, you set your organization up in this manner, and all of a sudden you lose that for conceding that you don't get, the corporation doesn't get all the rights, but to protect that individual exercise of liberty, you have to protect it in the corporate form.
Just one follow-up, if I may, so I understand the distinction between the individual and the corporation suing. Say Larry Page at Google hears a calling and decides to embrace Jesus Christ as his Savior and to run Google along Christian principles and promote Bibles in the cafeteria and so forth. Could he then sue in his individual capacity for an exemption, not only from the contraception mandate, but from all federal regulations that he believes violate his religious beliefs, including refusing to cover stem cell research or participating in medical care?
Or only hiring people of his faith.
Exactly. Basically, he wants an exemption from federal laws prohibiting discrimination on the basis of sexual discrimination for all of Google because he's got religion and says it violates his religious liberty. Would that be okay?
Well, I don't know how much of a, whether he still has majority control of the company. There have to be a complicated test about whether this is, part of the mission of the way that you do business, whether it's just that one shareholder is not even a majority who are asserting this right that's being violated. You could have one share and you disagree with what, from a religious perspective, let alone other ways of what the company is doing, and the solution there is, sorry, just sell that share. So there's a lot of things involved there. In terms of, you look at these rights in different ways in the context of the application of different laws. There was one recent corporation that won unanimously at the Supreme Court when the government tried to affect and impact its employment policies. This is the Hosanna-Tabor case, where the court ruled that, yes, they're allowed to fire this person for not, it was a school, a religiously denominated school that was a corporation. I don't know if it was for-profit or not. But one of their tenets was if you had a dispute, you had to bring that to the intra-church arbitration process rather than suing. She didn't do that. They fired her. And the court didn't get into questions of whether she was really a math teacher or a religion teacher. They said, that we don't want courts getting involved in that sort of thing. There's this ministerial exception, and we will take you at your word that this is part of your faith, and we'll do it that way. So it's kind of a complicated inquiry, a much more complicated inquiry for a large company, again, whether corporate or not, like a Google. But it would look at things like who's really controlling. Is this really a does the company have a sincere religious mission, or is this some sort of pretext? But they don't really want to get too much into is this a real religion, or is this these sorts of thorny questions. But there are the hard questions make for hard law, and we'll come to the big Google question at some point perhaps. But certainly for the Hobby Lobby, for these other companies, which can be quite good, quite big. Hobby Lobby is I don't remember what their annual sales are, but it's not insignificant. And in the way that they're formed, there's no question that all of their shareholders are feeling religious injury.
Great. Well, David, what's your response to this idea? It might be a complicated test, but it could be appropriate to ask whether Larry Page, after he's found religion in fact controls enough of Google to get these religious exemptions? And what about this Hosanna Tabor case, which Ilya mentioned, which granted a ministerial exemption for this institution?
Sure. Well, let me. Ilya said a lot of different things. Let me try and respond, hit some highlights, and I'm glad he raised Hosanna Tabor because that kind of raises a lot of very important issues in this case that we haven't really touched. I mean, one, so having a mantra does not make you a person that exercises religion that allows you to invoke the free exercise right. And I feel like hearing these arguments that, well, lots of corporations can have a mantra, I think just shows you how hard it is to wrap yourself around the idea that corporations have rights of conscience and human dignity to exercise religion in the same way that living, breathing humans do. Two, it's very important to focus on sort of how Hobby Lobby is claiming to exercise religion in this case. The owners of these corporations want to impose their religious views on their employees who don't have to share that view. When you work at Hobby Lobby, you don't have to subscribe to the same view that their owners do. You can be a member of any religion, and Hobby Lobby certainly has said that they hire across religious faiths. And I think, but when it comes to the mandate, they say our employees are not allowed to have this important federal right that the law provides that ensures that that women employees and their families have access to the full range of contraceptives. And I think some of the examples that Jeff raised, sort of shows what is the stopping point if you say an owner of a corporation can say providing this right offends my religious belief. So if you have a same-sex married couple who wants to use rights under the Family Leave and Medical Act to take care of an adopted child, can a business corporation say, well, I'm against same-sex marriage, so I'm not going to provide you that leave, and I need an exemption from that? Could a Muslim employer say, I will not pay for any medication that involves the use of a pig in the drug, or perhaps a heart transplant involving a pig? There's really, once you start that an employer, a for-profit secular employer, can say that providing rights to their employees violates their own corporate conscience and requires an exemption, I think you're sort of transforming sort of the way business corporations work and the rights of employees across a huge number of contexts, and making it easier for employers to discriminate against employees who don't adhere to their religious code. And to me, that turns the idea of religious liberty on its head. And finally, let me get to Hosanna Tabor, because it connects to this point. So Hosanna Tabor deals with a religious employer, and under these regulations, those employers are exempt. And so Hosanna Tabor says, a church can hire its own, and John Roberts, in that opinion, says the text and history of the First Amendment gives special solicitude to the rights of religious organizations. And in many ways, the question in Hobby Lobby is, will the court say business corporations have the same rights as religious organizations? And I think if the court reflects on sort of the tradition we have, which again, so you can go back to the framing, and the earliest corporate law recognized the fundamental difference between business corporations that existed to make running a business more profitable and religious corporations that were organized to allow human flourishing of religious beliefs, and recognizes that people often exercise religious beliefs in a communal setting, in a synagogue or a church or a mosque, what have you. And I think the law, Hosanna Tabor is one example, but there are lots of areas where the law says religious corporations have more freedom. So in Title VII of the Civil Rights Act, which is the main employment discrimination law, if you're a church, you can say, we want to hire our own. And that's how a religious association kind of stays a religious association. They hire their own believers, and that allows them to fulfill their mission. And Title VII says, yes, you can do that, and the law provides an exemption for religious corporations. And no one has ever dreamed that same freedom exists for business corporations. So if Hobby Lobby or if Google says, we only want Christian employees, that would be a patent violation of the Civil Rights Act. And I think the claim made by Hobby Lobby is, well, no, maybe they deserve an exemption from all these laws. And in some ways, the claim is sort of tearing down this fundamental distinction between the rights of religious organizations, which has been recognized, and the rights of business corporations, which never have. And I think the contraception mandate, in a sense, is kind of gets our principles very deeply right, because it recognizes the case of religious employers as a special one, and they do get exemptions that have never been extended to business corporations.
Great. And just to understand that final point, the Affordable Care Act does make an exemption to the contraception mandate for religious organizations narrowly defined. There's a question in this case of whether the definition of religious organizations is broad enough, and then the challengers are saying we shouldn't limit it to religious corporations, it should also include non-religious secular corporations. We're having a head shake in the second row, and we're going to get to questions in a second. But Ilya, as in any good, sophisticated NCC debate, David just made 3 big points. First, he said the Hosanna Tabor case is different. That was an exemption limited to a religious organization. It would be a big stretch to extend it to a secular nonprofit. Second, he said it would impose the religious beliefs of the owners on the employees. And third, and most broadly, and I'd love you to engage this point, and then we'll go to audience questions, he said this would really be a wedge into creating exemptions from a whole host of federal regulations. And Judge Rovner, in her dissent in the Seventh Circuit case, made this case too. I'm going to read, Ilya gave a bunch of examples. She gave some more. He said a ruling along these lines has the potential to reach far beyond contraception and invite employers to seek exemptions from any number of federally mandated employee benefits to which an employer might object on religious grounds. For example, a Methodist might object, and who objects to stem cell research might refuse to cover an employee's participation in a clinical trial of stem cell research for Lou Gehrig's disease. A Christian Scientist employer could say that the mandate of coverage for traditional medical care violates his religious beliefs, and a Southern Baptist employer who objects to gay marriage and surrogacy might refuse family leave to gay employees that would otherwise be required under federal law. Lots to chew on, but what are your responses?
Well, I mean, in a pluralistic society, we can't have exemptions for everything. I mean, the test isn't simply, isn't and shouldn't be simply, does this law infringe on, my religious beliefs or my religious practices? If so, then it doesn't apply to me. That's not the test. The Social Security case, there's a lot of people who say that it violates their religious beliefs to pay taxes or to pay that percentage of taxes that goes towards making bombs or making war or what have you, pacifists, Quakers, whoever. Those cases were, all went for the government, and correctly so. We get into some difficult issues here, but ultimately, the test that the court applies now under the Religious Freedom Restoration Act is first whether there's a substantial burden on the religious practice. Is it a generally applicable law? Then is there a substantial burden from that generally applicable law? And is this particular law still kind of the most narrowly tailored way that the government can achieve its compelling interest in pursuing the law? So there's a lot of hoops to jump through before you get to win your exemption claim. Some of those examples might be real. The particular, they don't want to cover these types of contraceptives for abortifacients. They also don't want to cover stem cell treatments. That's maybe the same type of claim. Some of these other ones about family medical leave or other kind of more broader ones probably fall on the outer edge, too much accommodation of religious minorities, perhaps, or majorities, whatever the case may be. But that's kind of the difficult, tricky part in the doctrine. I want to address a point that David's been arguing kind of throughout from his opening statement about that this is Hobby Lobby trying to impose their religious beliefs on their employees. It doesn't seem like that's what they're doing. They're not saying you can't, we won't hire you if you use contraceptives, or they're not saying anything that they even disapprove of employees, there's going to be flyers on their paycheck or a message on their paycheck, don't use contraceptives or anything like that. The employees are still free to go out and, if they get this exemption or before Obamacare, are free to go out and pay for it or get another type of coverage or whatever the case may be. The question arose when the government imposed this mandate and that conflicts with their religious beliefs. So the employees still have their right to access contraceptives. What they don't have, if the exemption goes through, is to have their employer pay for it. And curiously, it's not even clear whether that's a right because they don't have the right to sue their employer if their employer doesn't provide it. Instead, it's the government that would be fining the employer or otherwise regulating that. So there's some question about whether this is even a new federal right to begin with.
Wonderful. Well, usually at our town halls, we ask you to write your questions down, but if any group has earned the right to ask questions directly, it is this magnificent group of lovers of constitutional deliberation.
Oh, there's one thing, 'cause there's the third point. To address, to address the third point about the religious versus non-religious businesses, I guess, although one of the plaintiffs in Hobby Lobby, or it might be in Conestoga, some of them have co-plaintiffs, I forget which one. They all have individuals attached just to get standing and all these other things. One of them is a Christian bookstore. I mean, it's not a church. It's not attached to a church. It's a for-profit business that sells Christian books. You could imagine also the kosher deli, all of these types of purely commercial organizations that they're not engaged in social services. They are definitely for profit. They're in it to make a buck, but they abide very explicitly by the tenets of certain faith. That could you don't have to think hard to think about propose a federal regulation or a state regulation that might conflict with those. So I don't think the test is in that sense can be for profit or non-profit or even religious or non-religious in that sense. I'm not sure exactly. And I don't know whether then it's, if it's a partnership, it's okay, but if it's a corporation, it's not for some reason. But anyway, I'll leave it there.
Let me have your questions. If anyone is unsure about what's going on, please fess up, because in any good discussion, we're all grappling toward understanding in this complicated question. So if it's about the facts or about anything, share it, and we'll try to sort things out. Yes.
I wanted your opinion. Oh, sorry. Thank you. Sure. I wanted your opinion first addressing the issue of free speech. This strikes me as very different from free speech, because if I don't want to listen to what you're saying, there's no problem with my turning you off. And so this is very different. If you, as the corporation, have decided not to fund contraception, and I work for you and you provide me with my health care, your choice now offends my individual rights, because you are forcing me to now spend money to get coverage that you are giving me as an employer. So it seems to me the fundamental issue here is when the employer exercises their rights, does it violate my rights? My right as an employee, and I'd like you to look at that. Seems to me to be the core of this.
Great question, David.
I mean, that is why I've made the point over and over again, as Ilya said, that the claim by the owners of Hobby Lobby is that they can deny to their women employees and their families access to insurance coverage that would provide coverage for the full range of contraceptives. And I don't think it's an answer to say, well, they can buy it elsewhere. I mean, the point of providing this, I think the history is that insurance companies wouldn't cover contraceptives for women on the same basis as prescription coverage for men, and it was necessary to put in this requirement so that women employees and their families would have access to the full range of contraceptives, and without it, some would not be able to obtain access to those contraceptives. So I think this claim is extremely troubling and raises these host of hypotheticals that I mentioned, that Jeff mentioned, that Judge Rovner in a similar case in the Seventh Circuit mentioned, because the claim is, and it's in that sense, it's very much like the Amish Social Security case, where the Amish owner said, I need out of Social Security, I'm not concerned about what that means for my employees, but it offends my religious beliefs. And the court said, no, because giving you an exemption would be imposing your beliefs on them and denying them important rights provided by federal law. And I think that's the same analysis here. I think this case is harder than that because it's not an individual owner, but it's a corporation who wants to be treated as an individual for some purposes, but also be treated as a corporation when it comes to all the special privileges that go with corporate status.
Well, what we're missing here is the prong in our law, in our jurisprudence, that the government, if it has a less offensive way of achieving the same goal, it has to pursue that. And here, it's very easy for the government to provide the same, if the goal is to get people free contraceptives, the government could provide a tax credit or a tax break. They could set up free clinics to provide people. I mean, there's an infinite number of ways that the government, other than infringing on religious liberties, could achieve the exact same goal. And so that ultimately is why, on the merits, forgetting about whether it's the corporate right or whether corporations have right or the individuals acting through a corporate form or what have you, but setting that aside or getting past that to the actual merits of the claim, that's why ultimately under the Religious Freedom Restoration Act, passed overwhelmingly, unanimously in the House and something like 93-7 in the Senate in 93, this bipartisanship that seems so alien now. That's the standard. And Social Security or taxation can't meet that standard. There's no way to achieve the same kind of general level of taxation without having everyone in it. But there is a way to achieve getting people free contraceptives.
Wonderful. I see lots of hands. Let's try to get through as many as possible. Yes, sir.
The corporation is a voluntary association, as is many organizations of voluntary associations. In a voluntary association, one recourse is always to resign, to leave the association. Now, if a corporation requires an employee, or any organization requires a participant to do something which is legal, but the participant feels is immoral, that person has a right to resign from the organization and to leave the voluntary organization. On the other hand, if the government now requires a voluntary organization to require their people to do something which they regard as immoral, they again have a right to resign from that organization. Given that that is always a recourse, it seems to me the argument that that a corporation cannot reject a requirement of the government, since the participants always have a right to resign from that. They have a right to resign. The owners of Hobby Lobby have a right to sell off their business and leave it if they're required to do so. To me, that supports the argument that the corporation or any voluntary organization does not have the rights of individuals, because that option to resign is always there.
Ilya, why don't you start with that?
Yeah, well, again, under RFRA, the Religious Freedom Restoration Act, if the government imposes a substantial burden, so the question is this a substantial burden? Well, they could just close up shop and sell it off. If that's their only recourse, that seems to be a pretty substantial burden altogether. They like what they're doing. They've made it their life's work to provide this, craft store emporium and while promoting, their vision of the good life and what have you. And to say that, well, you can just leave, you can stop that activity, that burdens them. But I think it also makes society poorer. I mean, there's the bakery in Oregon, which had to close down because it wouldn't be allowed, not to create cakes for gay weddings and things like this. When there's lots of bakeries around in Oregon, it's not like this is a public accommodation in the Jim Crow South or something like that. And so anyway, so if there's this substantial burden, can the government achieve the same goal without imposing that burden, saying, comply with this thing that violates your beliefs or completely sell off your business? Is there a narrower way of achieving that same goal? Yes, there is.
Yes, right in front.
You've talked about this a little bit, but is there a distinction between a closely held private corporation and one that's a public stock offering corporation in this regard?
It's a great question, and I don't know the answer. Can you explain to us the difference between a closely held corporation and a publicly held stock corporation?
I think it's a distinctive feature of these cases that if you look at not just Hobby Lobby and Conestoga, but all the other cases that are in various levels of the federal court, they tend to follow the same model that there's some family that has controlling power. I think the difficulty is when the Supreme Court gets down to writing rules for what are the rights of business corporations, they don't kind of say, well, we're going to create a special kind of protection in this instance, but not generally. I mean, so Citizens United is sort of an example. There was an argument, well, you should just write an opinion that says Citizens United should be entitled to spend its money freely without limit on political electioneering, but for-profit corporations should be treated differently. And the court essentially said no. And I think one thing to keep in mind is even when you're dealing with the smallest unit, which would be kind of a single corporation that is a single shareholder, the fundamental point which the court has recognized is the purpose of creating that is to kind of disassociate the two, to recognize that this is a separate legal entity with separate rights and duties, and of course the main reason that's created is to avoid liability. But so in practice, I think the court, while these cases all obviously involve this fact scenario, the court has to think about, well, if it's saying that a business corporation is a person that exercises religion, it's hard to sort of say Hobby Lobby, but not kind of the others. So I think in practice, the principle is one that will be more generally applicable, and that's why I think our debate here and most of the debates that you read about in the briefs and in the court and in the press sort of focus on this bigger question of what are the rights of business corporations, particularly secular business corporations, when it comes to the free exercise of religion.
Just briefly, you talked about creating a test. Might that be one?
No, I mean, no, I don't think you draw the line between public versus closely held. But I agree with David in that the principle has to apply more broadly. But in practice, it's going to be very rare for some big public company to assert these sorts of rights. And that's perhaps why you haven't seen the Googles or anything like that. Chick-fil-A, I believe, is a public company. I could be wrong about that, but they're not. I don't know whether they're what the owners of that company believe with respect to the contraceptive mandate. But in practice, it would be very rare to have such a huge publicly traded corporation that's able to maintain a religious mission or something like that. And perhaps that's why owners that have businessmen who have a religious calling keep their companies closely held and don't go public. Perhaps that's kind of an incentive or a disincentive in the law to maintain your corporation that way. So yeah, in principle, I don't think there's a distinction, but in practice, again, there would have to be some sort of test about control and who's being burdened and the size of the burden and all of these different sorts of things, which would have to operate differently for closely held than for public.
Great. Toward the back, sir. Yeah. Oh, just after.
My question follows kind of on the same lines, but a step farther. How would your analysis change if instead of an incorporated business, we were talking about a sole proprietorship, equal in every other way in size and line of work, but one that was run out of the owner's pocket rather than as a separate legal entity? Would he or she then be able to claim religious rights?
So not as a corporation.
Right, as a sole proprietorship.
I mean, I think that would be the kind of case that, I mean, I'm not 100% sure, but my instinct is that would be the kind of case that the court dealt with in Braunfield and Lee, and the court in those cases recognized some measure of protection. But I mean, I think one of the things that one has to sort of recognize, when we're talking about sort of the Religious Freedom Restoration Act and thinking about what's being restored, it's kind of a history of claims brought by businesses being rejected over and over again. And I'm not sure of, certainly not in the Supreme Court, of any case that, that won. But I suppose if you're just dealing with an individual owner, those would be governed by the sort of Braunfield, Lee, and the other sort of body of precedent that the court would look to with respect to RFRA. Braunfield was a case in 1961. That was the Sunday closing, where the court said you're not entitled to an
Jewish
exemption.
butchers.
The Jewish butchers who said you're not entitled to exemption. And again, they raised the problem of, it's not just an exemption for you, but it's an exemption for, for others in similar situations. And I think, in some ways you can't just sort of focus on the objections raised by these employers, but you have to think about sort of systemically, we have a system in which employee benefits of these sort are rooted through the employers, and how would that system operate if employers that claimed religious consciences would have an exemption? And so Braunfield is the 61 case. Lee is the 1982 case that
The
we
Amish
talked
Social
about,
Security.
the Amish Social Security.
Great. Just a few more questions. Yes, sir.
Many small businesses in this country are indeed C corps that are controlled by one person or 2 or 3 people. And as myself, I happen to have 100% of the shares of a separate corporation, so we're essentially 2 individual legal entities, which means that I'm able to spend a lot more money on campaign than the person who is not. Which doesn't add, I'd like you to address the issue that this seems to me to be unequal representation in terms of campaign contributions that me as an individual can exert versus others that are not owners of companies. So can you address the issue of the notion that I have more representation in this election process than the average person?
Well, to be clear, I thought you were going somewhere else, because small businesses or those under 50 employees are exempt from the contraception mandate. I thought you were going to make a point about that. But in terms of political speech, individuals can certainly donate to campaigns, although they're restricted to how much they can do to an individual campaign in aggregate over an election cycle. There's a case before the Supreme Court this year, the McCutcheon case that David and I have done a podcast for the NCC on about that. Corporations cannot donate to companies. Non-individuals, non-humans cannot donate to campaigns, PACs, candidates, that sort of thing, but they can independently speak. So I don't think that it's the case that someone who owns a company or sets up a company for the purpose of political speech has more rights in terms of being involved in the political process. Do they have more rights by setting up that company to speak independently? No, also because it's still that same amount of money, and whether you're making that 50,000 TV buy with your own money or 50,000 with your own money funneled through this company, it's still ultimately your pocketbook's $50,000. So I don't think under either example, whether you're talking about independent speech or political contributions, that someone who's a business owner would have more rights.
Time for just one. Go ahead.
So just on that, so when the Supreme Court upheld the limit on corporate contributions, one of the rationales was that if corporations could
Corporate
make
expenditures.
no contributions,
Corporates can't make contributions.
right, when they upheld that,
Oh, right, yeah.
one of the rationales was that an individual could form a corporation, and if that corporation could independently contribute, they could get around the limits on individual contributions. And there have been some efforts to overturn that precedent, but I think this is one reason why those haven't really gotten anywhere so far.
Great. I think we have time for just one more question.
I
Yes,
want to change the focus slightly.
Wait for the mic so we get it on tape.
I want to ask you, instead of talking about what you think should happen, are you willing to make a prediction about what you think will happen with this Supreme Court and its members and their ideologies?
Great question. Always tough to be a pundit, but that's why they pay us the big bucks. So what's going to happen in the Hobby
Do you
Lobby
charge
case?
for admission to these things?
We should pay the audience for having
No,
showed
because,
up today.
because I was going to say that my prediction is worth what you paid the price of admission. But if you paid something to get in, it's worth less than that. Luckily, I don't make a living by successfully predicting the Supreme Court. I don't think anybody does. It's not really a real possibility. But I think the plaintiffs will win. I think it's the corporate rights, however they articulate who owns the individuals, passing through the corp, or the corp has its own rights. They'll find standing. They'll find that somebody has these rights. These rights are being violated, and there's a narrower way of achieving the same goal. And therefore, what the vote's going to be, I don't know. It won't be unanimous, I don't think, but there could be splits in terms of these various aspects of the particular cases. But I think I'm willing to predict that at least one aspect of the case won't be 5-4.
I think it's very, very hard to predict, and certainly, the last major ACA case in the Supreme Court, frustrated every pundit's predictions. I mean, just sort of two observations, about some of the justices. So, Justice Kennedy, sort of the perennial swing vote that everyone loves to follow, was in the majority in a 1990 case called Employment Division Smith that really cut back on exemptions under the Free Exercise Clause and was the occasion for RFRA's passage. So he joined that. He also authored the opinion in City of Bernie, which struck down RFRA as applied to the states, which of course deals with completely different issues, but that's a background that suggests he may not come to this case as a fan of RFRA, and I think one of the big issues in this case is, how far will the court go to interpreting RFRA in a way that business corporations will be allowed to seek exemptions in a number of cases. The other person who, this case is perhaps an interesting dilemma for is Justice Scalia, who, is on record as a very kind of staunch opponent of exemptions, at least, so he authored the Employment Division versus Smith case, which essentially said, generally you don't get an exemption because, the fact that you have if we grant exemptions as a matter of some frequency and impose this very high standard of proof, religion sort of becomes a law unto itself. He was the author of that opinion. He also authored a very interesting concurring opinion in the Bernie case, which responded to objections that the Employment Division versus Smith ruling was out of step with the views of the framers of the First Amendment. So, and interestingly responded to conservative originalists like Michael McConnell, who said that ruling was, on the other hand, I think you could see him having some sympathy with this claim that employers who have an objection to these forms of contraceptives shouldn't have to pay. So I think he is sort of in an interesting position because he is on record so much. And in some ways, these cases are so hard to predict because the court has said very little in quite a long time about free exercise. And I mean, as I mentioned in the outset, for over 2 centuries, no one has said that business corporations have the same rights to religious exercise as living, breathing persons. So this is really a huge case that has stakes well beyond Obamacare. So I think it's hard to sort of predict how the justices will
Let's just remember, it's under RFRA that we're talking about. It's not a pure First Amendment free exercise case. And that's why I think it's much easier than it might look otherwise, because RFRA is pretty clear in terms of its requirements. Yes, without RFRA, under Employment Division versus Smith, it's a whole new court. I mean, that would be a jump ball, I think. And there's, I'm of 2 minds of Employment Division versus Smith, as was the court. I mean, it wasn't a liberal-conservative breakdown. That's, I think ultimately, because this is a case of statutory interpretation, there's a lot less going on here than might otherwise people think.
I mean, but Ilya is certainly right. So the question is, under the terms of the Religious Freedom Restoration Act. But the whole point of the Religious Freedom Restoration Act was to restore the pre-Smith law. And I mean, as I said, I think part of the problem for Hobby Lobby is that the history of the pre-Smith law was sort of total failure of claims by business corporations or business owners, not to get exemptions from laws.
Ladies and gentlemen, looking out the window, in our beautiful view toward Independence Hall, I see that the illuminating rays of this discussion have warmed not only this room, but all of Independence Mall, and it's no longer snowing. I'm so proud. Oh, it's snowing a little bit, but I think your trip home is going to be a lot easier. What I want to do now is take a vote, because the whole point of these discussions, remember, the National Constitution Center, as I never tire of saying, is the only institution in the country chartered by Congress to disseminate information about the United States Constitution on a nonpartisan basis. We bring together the best arguments on all sides of the constitutional debates that transfix the country and allow you to make up your own minds. You've just heard an extremely sophisticated, nuanced, and complex discussion, not about political issues, but about constitutional issues. And you've recognized that, like all important constitutional questions, the answers here aren't easy. Nevertheless, at some point, the justices are going to have to vote. So why don't we, in our role as engaged citizens who braved the snow to talk about this, take a vote? And I want to ask you this. Do you believe that the Affordable Care Act's refusal to grant an exemption to the Hobby Lobby Corporation, a religious bookstore, violates the corporation's liberty under the Free Exercise Clause of the First Amendment? Who believes that the Free Exercise Clause is violated by the refusal to grant an exemption to the Hobby Lobby case? And who believes it is not? All right, this may not be a representative crowd.
That's not the real question. And I don't think anyone questions that there's a violation, but the question is the government justified in still pursuing it?
Or you want to try it again that way?
No, I don't think the result.
All right, nice try. Ladies and gentlemen, I want you to do something else. This really is the loyalist of all of our members, the contributing scholars in the face of arduous weather conditions. What I would love you to do is either leave your business cards, or we'll just put a sign-up sheet outside by the coffee machine, and leave your email address. I won't spam you. I just want to make sure that you are aware of all of our town hall debates. If you're not already on our mailing list and you haven't joined as members, which I hope and assume you will. The next one, I think, is January 24th, but we will confirm, and it's scheduled now to actually be about the broader questions involved in the latest constitutional challenge to the healthcare mandate, which include not the question we were talking about today, but whether first, the president has violated his duties to take care that the laws are faithfully executed and delaying implementation of the mandate. Second, the claim that the, my God, can I even do them all off the top of my head?
Origination clause?
The origination clause, that because the bill originated in the House but not the Senate, it violates the origination clause.
Other way.
And then, nobody's perfect, right? Who's squabbling? It should have originated in the House and not the Senate, and therefore it violates the origination clause. And finally, and actually the one that has most legs, interestingly, the text of the statute, if parsed very closely, seems to only grant a tax exemption to exchanges that are created by states, but not the federal government. Does the Obama administration's decision to extend this exemption to federally created exchanges violate the text of the statutes? Those are the thrilling, riveting constitutional questions that we'll debate in January. Thank you so much for joining us for a wonderful discussion. You make me proud to be the head of this center. Thank you for showing up today.